at the former Nakawa Nagulu housing estate. Right Honorable Speaker, the report is uploaded on the members' iPads, and if members can follow, you will realize that the background of this issue is that on the 15th of October 2007, the government of Uganda, through the Ministry of Local Government, signed the PPP contract with OPEC Prime Properties Limited and OPEC Uganda Limited, hereafter called the developer of Nakawa Nagulu housing estate, into two ultra-modern satellite towns through the construction of modern residential, commercial, and institutional properties and premises. This included the construction of 1,747 modern subsidized dedicated residential units for the purpose for the purchase and resettlement of the registered tenants of the Nakawa Nagulu estate. The principle of this project, Madam Speaker, was that government contributed 53.226 hectares of land at Nakawa Nagulu, while the developer was responsible for financing and for technical and operational obligations and the risks in the design, financing, building, and operation of the project. The full cost of the project was to be met by the developer. The developer was expected to have completed the dedicated residential units for the sitting tenants not later than 4 years from the date of signature of the agreement, and the entire project within 10 years from the date of signature of the agreement. However, the project could not take off immediately due to challenges of securing vacant possession of land, court injunctions by former sitting tenants, and investigations by IGJ that halted the project for some time. Consequently, Madam Speaker, the parties signed Addendum 1 of the PPP agreement on the 10th of December 2012 to cater for the lost time and to introduce other amendments to move the project forward. The project site was officially handed over to the developer at a groundbreaking ceremony that took place on 14th October 2013, presided over by none other than HA, the President. The project still did not take off, and on 28th of October 2015, the parties signed Addendum 2, in which the developer agreed to surrender 24.426 hectares of land at Nakawa land back to government, leaving the developer with 28.8 hectares of land at Nagulu land. The surrendered portion, Madam Speaker, was reallocated to the Aga Khan for construction of a modern university teaching hospital. Under Addendum number 2, the developer was supposed to continue with the project at the Nagulu site within the timeline stipulated under the PPP agreement, Addendum number 1, but still no progress was made, which prompted government to terminate the agreement on the 9th of August 2018 on grounds of failure by the developer to fulfill its contractual obligations. Honorable members, it is against this background that the committee conducted a fact-finding inquiry to ascertain the current status of the Nakawa-Naguru land following termination of the PPP agreement. If you read through, you will see the terms of reference and indeed the methodology that was used to generate this report. On page 6, Madam Speaker, we have our findings, observations, and indeed the recommendation. On current ownership status of Nakawa-Naguru, Madam Speaker, on termination of the PPP agreement, the developer in August 2018, government through Uganda Land Commission exercised its right to re-enter, and the leasehold titles which had been issued to the developer were cancelled. The committee reviewed copies of these and confirmed that indeed they were cancelled. The committee, however, noted that Uganda Land Commission is in the process of allocating the land to private persons, as will be noted later in this report. On page 7, Madam Speaker, on whether the interests of the former sitting tenant of the Nakawa-Naguru housing estate and other affected third parties have been protected. Government's decision in respect to third-party interests on the land. The committee learned that following termination of the PPP agreement, Cabinet under Minute 131 CT of 2019 took the following decision to protect interests of third parties who were affected by the termination. Former sitting tenants of Nakawa-Naguru housing estates. As mentioned earlier, under the PPP, the developer was required to use the land comprised of Nakawa-Naguru housing estate for, among other things, to construct 1,747 modern subsidized residential units for the purchase by and resettlement of the registered tenants of that area who would have entered the memorandum of understanding with the government and whose names were appended on the PPP contract. On the 28th day of June 2007, government signed a memorandum with those tenants in which they agreed to vacate the place for redevelopment. Following the PPP, Madam Speaker, Cabinet decided that the former sitting tenants each be paid an ex gratia amount of 17.7 million for the promise which government had made to them under the MOU. Madam Speaker, if I may move straight to our committee recommendation in light of that on page 9, the committee recommends as follows. Government should consider increasing the amount to be paid to each of the former sitting tenants of the Nakawa-Naguru land, having regard to the value of the modern subsidized residential units which were to be constructed for the tenants and the anguish suffered by the tenants over the years because of the failure by government to replace their homes which were demolished to pave way for the project. B, payment to the former sitting tenants of Nakawa-Naguru land should be halted pending verification of the list of the registered former sitting tenants by the Auditor General to ensure that only the tenants who are eligible are paid. Madam Speaker, pre-existing title holders and institutions on the land. The committee noted that prior to the execution of the PPP agreement between government of Uganda and the developer, there were existing title holders and public institutions on the public land. The interests of the existing title holders and institutions were recognized under Clause 3 of the PPP agreement, and the developer had agreed to accommodate them in its overall plan of the satellite city. During our visit, Madam Speaker, on the land, we realized that there is KCCA Nakawa Division offices. There's also Naguru Infant Primary School and St. Peter's Church of Uganda. The committee further established that Ntinda Wholesaler and Distributor, which had acquired land in Nakawa prior to the PPP agreement, was subsequently requested to swap it for land in Naguru to make way for the Aga Khan Medical Teaching Hospital, which was allocated in Nakawa to the developer. Madam Speaker, Cabinet directed the Ministry of Land, Housing and Urban Development to process and issue titles to the pre-existing institutions as follows. KCCA Division Offices, 3.01 acres. Naguru Infant School, 1.06 acres. St. Peter's Church of Uganda, 0.98 acres. Ntinda Wholesalers and Distributors, 2 acres. The National Library of Uganda, 2 acres. However, by the time of reporting, the institutions had not yet been issued with the land titles. Therefore, the committee recommends that the Ministry of Lands, Housing and Urban Development expedites the issuance of titles to the public institutions to safeguard the interests of the institutions, more so that government has decided to allocate the land to private persons. Madam Speaker, on the third-party claimants with developments in Naguru, the PPP agreement under Clause 6.1 and 11.0 recognized that the developer was at liberty to mobilize resources from third parties for the purpose of delivering the project. Accordingly, Cabinet directed that the third parties who had been engaged by Prime OPEC and had made some developments on the land be leased those portions they had developed, provided they meet the terms and conditions of the lease. Consequently, Madam Speaker, Cabinet constituted an interministerial subcommittee chaired by the Minister for Kampala, Capital City Authority and Metropolitan Affairs, with the mandate to directly engage the third parties that had developments on the land which arose out of their relationship with OPEC Prime Properties. The interministerial subcommittee established by Cabinet constituted a technical committee to inter alia conduct a survey to map out 12.17 acres to third parties with developed portions of land to ascertain the claims of the third parties, which the third parties with undeveloped portion of land, and advise on the status of their legal interest. It is worth noting, Madam Speaker, that the Solicitor General had hitherto given a legal opinion to the Permanent Secretary of Ministry of Lands, Housing and Urban Development on request by the Ministry. That was on the 8th June of 2020, in which he advised that for third parties who had made developments on the land, only and only the developed portions of the land measuring 12.17 acres, with emphasis, should be leased out to the said developers in accordance with the cabinet decision, following decisions with the interministerial committee on the terms and conditions that will be set out and agreed by the committee. However, Madam Speaker, the other persons and companies that entered into agreement with OPEC Prime Properties Limited, the Solicitor General opined that they had no claim whatsoever against government based on the principles of privity of contract. The opinion of the Solicitor General was subsequently clarified by the Attorney General in a letter to the chairperson of the Uganda Land Commission on the 8th day of July 2020, which was in response to the letter by the Uganda Land Commission dated 23rd June 2020. In the letter, the Attorney General clarified that individuals and companies that bought land from OPEC Prime got no interest in the land following termination of the PPP agreement by government, which formed the basis for the grant of the land to OPEC Prime, and once terminated, Madam Speaker, the land reverted back to government. Regarding the companies and individuals who had developed some parcels of land pursuant to the joint venture agreement with OPEC Prime Limited, namely Rocco Construction Limited and Malt Consult Designs Limited, the Attorney General advised ULC to implement the cabinet decision in respect to this category of third parties, working together with the interministerial subcommittee constituted for this purpose. The report of the technical committee took cognizance of the Attorney General's legal opinion on the Naguru land and the directives of cabinet, third parties who have developed portions of the land. The report indicates that there are 6 known and 2 unknown claimants with developments on the land, measuring 15.8 acres. Members, you will note that the first was 12 acres, now it has increased to 15.2. The unknown claimants are Rocco Construction Limited, which is claiming 9.344 acres. Malt Consult Design, these are the known claimants include Local Construction, 9.433, Malt Consult Design, claiming 3 acres, and one Luchamuzi and Hakim Mulindwa. Then Acacia Properties Limited and Professor Gakwandi Shato, whose developments cover 2.884 acres in total. Now, during our visit, Madam Speaker, we found out that there are 19 physical developments or physical structures on the land as follows. 2 developments at foundation level, and one shell house. Shell house meaning some structure which is not even roofed. It is incomplete, belonging to Luchamuzi. 2 complete houses and 10 shell houses of the would-be townhouses allegedly constructed by Malt Consult on behalf of Rocco. There is 1 complete house belonging to Katomagala. There is another 1 complete house belonging to Professor Gakwandi Shato. There is 1 house which is still under construction, Madam Speaker, belonging to Hakim Mulindwa, and a huge slab which was constructed by Rocco to accommodate the first 200 units for the former sitting tenants of the Nakawa-Naguru land. However, due to limited time, the committee was unable to interface with those third parties under that. But the committee noted that whereas the report of the technical committee indicates that ROCO had developed on the land measuring 9.344 acres during the locust visit, it was established that the only developed land, Madam Speaker, is a slab which was supposed to carry 2,000 units for the former sitting tenants, and it covers an area of 1.7 acres, not 9.344. Therefore, the technical committee's recommendation that ROCO should be allocated 9.344 acres, when in fact the company has developed only 1.7 acres, has no merit, considering that the Attorney General had hitherto opined that the third parties with development on the land should be leased only the portions on which they had development. Madam Speaker, the committee was informed that ROCO is still interested in the continuing of the construction of the 200 units on the existing slab, and therefore the allocation of the additional 7.75 was intended to enable ROCO provide space for amenities such as parking space, and they would be and that would support the units to be constructed according to the plan by KCCA. The committee, however, notes that in November 2014, when ROCO was engaged by OPEC, up to August 2018, when PPP was terminated, the company had failed to construct the 200 units that was contracted to it. It is therefore risky for government to allocate ROCO an additional 7.7 acres when it failed to develop the first 1.72 acres for the period of almost 4 years. During our visit, Madam Speaker, the committee established that the physical structures which were erected on the land do not meet the standards of an ultra-modern satellite city envisaged in the PPP agreement. As a matter of fact, the houses of the former sitting tenants, which government demolished on the basis that they were dilapidated, were high-rise apartments and of much better standard than the structures currently existing on the land. The committee therefore recommends that if government is to proceed with its plan of developing the land into an ultra-modern satellite city, then it should consider an ex gratia settlement for the third parties with developments on the land, as opposed to granting them leases, since their developments were incompatible with the envisaged ultra-modern satellite city. Madam Speaker, on the third-party claimants with the developed plots, the technical committee of the cabinet, subcommittee of the cabinet considered their claims with undeveloped portions of land and the status of their legal interests. Madam Speaker, in the regard to the technical committee constituted by the subcommittee, which comprised of State Attorney, Senior Inspector of the Ministry of Lands, Principal Legal Officer, Ministry of KCCA, the legal subcommittee established that there were a total of 12 third-party claimants who had agreements with OPEC Prime, and these were Kampala Associated Advocates, 1 acre, Professor Henry Kirali, Dr. Lucy Kirali, and Dr. Grace Kirali, care of their attorney, Okech Baria Young and Advocates, 1.085 acres. Professor Arthur Shatok Kwandi, 0.8 acres, 0.98 acres. AFG International Limited, 2.74 acres. Delta Worth Focus Investment, 0.9 acres. Elisa Brookie, 1.09 acres. Luchamzi Investment, 8 acres. Buita Limited, 1.57 acres. Acacia Properties, 9.5 acres. Sesti Supplies Limited, 1.9 acres. Katomagala, 0.16, and Akim Mulindwa, 0.5. Madam Speaker, when we go forward to the presidential directives on page 15, the committee was informed that the president directed that part of the land be allocated to the International Medicine of Virginia, 15 acres, Uganda Heart Institute, 10 acres, and Mediheal Group of Hospitals, 7 acres. The committee was availed with copies of the presidential directive, Madam Speaker. However, whereas the report of the technical committee of the interministerial subcommittee indicates that presidential directives were implemented, a letter dated 22nd March 2021 of the Uganda Land Commission to the Minister of Lands, Housing and Urban Development indicates that Mediheal Group of Hospitals was not allocated land at Naguru Estate by ULC because the President's directive was received after the allocation had been completed. In the letter, ULC instead offered Mediheal Group of Hospitals 7 acres of land at Butabika Hospital. Indeed, a document was availed to the committee titled Naguru Project Land Survey, which indicates that the hospital was not allocated the land. Madam Speaker, on term number 3, term of reference number 3, allegations of allocation of Nakawa Naguru land to private individuals under unclear circumstances. The residue of land after deduction of the third-party claims, according to the report of the technical committee, the total acreage of the Naguru project land is 82.54 acres, which is 33.4 hectares, while the residue is 42.5, which is about 17.22 hectares. After deducting the land for public institutions and the third parties and the presidential directives. Madam Speaker, it is worth to note that some of the cabinet proposals for the land allocations were not implemented by the Uganda Land Commission. For instance, the allocation of 7 acres of land to Mediheal Hospital by cabinet pursuant to a presidential directive was not implemented, while ULC allocated ROCO and Multi-Consult Design Limited 2 acres of land each, as opposed to 9.344 acres and 3 acres respectively proposed by cabinet. In addition, the proposed allocation of 2.88 acres to other third parties with developments on the land was not factored in the ULC allocations. Therefore, according to ULC, the available land after deduction of the land under presidential directives, pre-existing title holders and institutions is only 50 acres. And there is a table showing the allocations of land by now the Uganda Land Commission. The other one was by cabinet. Now this table has a library, National Library, 2 acres. There's Anil Damani, 3 acres. There's Arab Oil Supplies and Exploration Limited, Dashen Uganda Limited, Dembe Enterprises, 4 acres, Dominion Partners Limited. The list is long, Madam Speaker, but the total is 50 acres. Madam Speaker, the rationale for allocating the land is there explained, and the criteria by the ULC on page 18. On page 19, Madam Speaker, the committee recommends that ULC should subject the applications of the allocators to a rigorous due diligence exercise to ensure that they were technically and financially capable of developing the land. The due diligence exercise should be conducted within a period of 1 month from the date of the adoption of this report to avoid any further delays to the redevelopment of the land. Madam Speaker, the committee noted that the apparent lack of coordination between the Ministry of Land and the ULC in allocating the land, which if not addressed will breed unnecessary land conflicts. Whereas the ministry is implementing the directives of cabinet on the Nakawa Nagulu, ULC is allocating the same land without giving due considerations of the proposals by cabinet. This has led to the creation of overlapping interests on the land, which is a recipe for land disputes. Madam Speaker, the committee observes that this modus operandi is not healthy for the development of the land, housing and urban development sector, considering that the mandate of the 2 institutions are so interlinked that one cannot do without the other. For example, the ULC needs the ministry to generate survey maps for the land it allocated and to issue the allocatees with land titles. At the same time, the ministry is vested with the mandated to provide policy guidance over the supervisory oversight of the ULC, which it cannot do effectively in the prevailing circumstances. Madam Speaker, given that background, the committee recommends that the Right Honorable Prime Minister should intervene and resolve the disagreements between the Ministry of Lands, Housing and Urban Development and the Uganda Land Commission to facilitate a smooth implementation of the planned project at Nakawa Nagulu. In regard to the attempts to usurp the mandate of the ULC, Madam Speaker, under Article 238 of the Constitution of the Republic of Uganda and Section 46 of the Land Act 1998, the Uganda Land Commission is vested with the mandate to sell, lease, or otherwise deal with the land held by it. However, the committee noted that there were attempts by Cabinet and the Ministry of Lands to usurp the mandate of the Commission by issuing directives to the Commission to implement as opposed to making proposals to the Commission to consider. In attempting to reassert its mandate, the Commission found itself on a collision course with the Cabinet. The Minister of Lands, Housing and Urban Development wrote several letters to the chairperson of the Uganda Land Commission directing her to implement Cabinet decisions. Copies are attached here too. In addition, the Attorney General's opinion to the Uganda Land Commission dated 8th July 2020 was crafted in a way that undermined the mandate of the Commission. If I may read it verbatim, here it goes. All subsequent allocations made by Uganda Land Commission without cabinet approval should be rescinded as it is in breach of Cabinet Minute number 131 of 2019-5 that authorized the Cabinet Subcommittee to make proposals for Cabinet's approval of the investments to be undertaken on the recovered land. Madam Speaker, the committee notes that the role of the Ministry of Lands, Housing and Urban Development is to provide policy guidance to the ULC, but not to allocate land. Therefore, the Uganda Land Commission should be allowed to exercise its mandate without undue interference. The committee further recommends that Ministry of Lands should expedite the tabling of the Uganda Land Commission Bill to streamline the functions of the Commission and accord it the much desired operational and financial independence to enable the Commission exercise its functions independently, efficiently, and effectively. The general recommendations, Madam Speaker, in view of the foregoing, the committee recommends that A, the chief government valuer should establish the actual value of the existing developments on the land for future reference. Should government consider the option of paying the third party claimants instead of allocating them land. B, Uganda Land Commission should take the requisite legal steps to restrain the third-party claimants under the PPP agreement with OPEC Prime from proceeding with any further developments on the land, to protect government from paying colossal sums of money to the third parties for the developments made in the future, considering that the value of the property increases with each passing year. C, the KCCA, the Kampala City Capital City Authority, should expedite the process of updating the master plan for the Naguru-Nakawa area to take care of the changes in the land uses, and which should be aligned with the overall physical development plans for the city. In conclusion, Madam Speaker, the committee reiterates its support for redevelopment of the Naguru-Nakawa into an ultra-modern satellite city, as it will enhance the beauty of the area and at the same time boost government revenues in the form of taxes and non-tax revenues from premiums for the allocatees of the land to be subjected to a rigorous due diligence process to test their technical and financial capabilities to develop the land, so as to avoid the recurrence of the scenario of the previous developer who failed to develop the land. In so doing, government should consider the compatibility of the land uses proposed by the developers with the envisioned satellite city and overall physical development plan of Kampala. Madam Speaker, I beg to lay the report and the minutes that considered this report, I beg to lay.
Thank you. Thank you very much, Honorable Chair and the Committee of Physical Infrastructure. A few comments, Honorable Saungu Mwiru, Mbwa, we'll go to Gomba, Macho. 3 minutes each, please.
Thank you, Madam Speaker, and I want to thank the Chair for the report. But Mr. Chairman, to be frank with you, a lot is missing in your report, and I'm going to base on what you have submitted. Right Honourable Speaker, this is one of the areas or land that was given by government from 2006 when Shimoni was given out, and definitely nothing happened to that school until someone took the land, including Mbuya Army School land, and then in Naguru. Naguru land, honorable members, had very good structures, only not given a facelift by that time. And they were accommodating head teachers, Kampala State Council staff, including nurses, head teachers, those are the people who were staying in these buildings, and they were paying very well. Actually, right now, Speaker, what we are seeing here, on page, let me first go to page where they talk about allocation of this land and these people who have taken land on page 14. We are seeing a number of people, including Kampala Associated Advocates and what have you. But the report is not telling us how they got ownership, whether they are possessing land titles, and how they got them. Because when this land was being demolished, when the buildings were taken away, and government staffs were being sent out, they promised they were going to construct a city in 2007. But now, it has become a land bonanza. If you talked very well with the ULC, they will tell you even some ministers in KCCA there, they have already owned some parts of land there. And the committee knows that, they have that information, but it's not revealed here. Maybe the companies you are naming here. Right Honourable Speaker, we are seeing that the Attorney General, he is the legal advisor of government on page 21. And he says, in addition, the Attorney General's opinion, the Uganda Land Commission, dated 8th July 2020, was crafted in a way that undermined the mandate of the Commission in verbatim and Attorney General opinion. I don't want to read it. Now, if the Attorney General gives an opinion to the body in charge of our land, Uganda Land Commission, and he gives them an opinion which is against the interest of government, then he also has a conflict of interest and should be investigated. Should be investigated. Honourable Speaker, for me, as you gave us 3 minutes, I want to ask the committee and this House honourable members, let us give a decree on this land. It should not be tampered until we find out the facts relating to that land. Even those people who seem to be owning some land there, the 50 acres, how did they get it? Under which procedure? We need to know. These are thieves who should be hanged. They should be taken to prison. They are enjoying land. Naguru is a prime area. But people have taken interest because nobody is taking. Recently, no speaker, we had the army in the committee of park. And I asked them, when we were investigating the Otagenos report, I asked them, the accountant, the PS, and their soldiers there, that Mbuya Army School was your school. It was teaching army children. Who owns the land now? What they gave us is very interesting, and I'm going to get other copies. But we need to find out who are these people who have so far shared 50 acres at the interest of Ugandans. Since the project never took off, then land should revert to Uganda Land Commission as it was before. Then we sit and make new decisions on them, other than people sitting in the State Council there, KCCA ministers, have already got some acres there. And I will bring that here if it is needed to be brought, and I will give my evidence. And the committees are aware, they got that information. I don't know why you are not giving it here. You're only giving the Ministry of Lands, Urban Development is having a conflict with Uganda Land Commission. What is happening with Uganda Land Commission at no speaker? It is trying to save the land. Then the Ministry of Lands, people are also fighting to take the land the way they want, basing on the presidential directive. But I'm warning you, you heard what Mr. Museveni said on Labour Day about Umeme. He's accusing us, he's attacking parliament, he's attacking ministers. For him, he's a holy person living on earth with no sin. And Umeme is there. But all these things we said him in parliament here, and a number of things were said. So as I conclude, our speaker, Mr. Chairman, kindly unearth more information out of your report. You know what you got from the committee. Tell us facts and we put people to pain other than stealing government land. This land, Madam Speaker, honorable members, support me in stopping it from anybody sharing a single acre until we carry further investigation and the land reverts to Uganda Land Commission for better performance. Otherwise, the thieves, the vultures, the demagogues of this country are busy planning to steal that land. Thank you, Madam Speaker.
Now, Muiru. We have decided, then I'm coming.
Thank you so much, Right Honorable Speaker and colleagues. I want to thank the chairman and the committee for the report. Right Honorable Speaker, I'm looking at a big problem about land management in the country. And what the chairman is bringing out is just a symptom. It is part of the bigger problem. Right Honorable Speaker, when you read the mandate of Uganda Land Commission, they hold land in trust of the Ugandans because they're exercising that mandate which is conferred by law. Right Honorable Speaker, in exercise of that mandate, first we expect them to act independently. We have a problem in this country as to who is an investor. This is to start with. Honorable Speaker, I went to Uganda Investment Authority when I was applying for an investment license. So I said I want to an investment. Then the girl asked me, what is the investor? I said I am the investor. They thought I'd come with either an Indian or a white, because investment now is attributed to color. Because when Honorable Speaker, I do due diligence of most of these companies, these individuals given this land, don't take this land too. They are paupers. They don't have any money to do any development. That's why, if one asked these companies to whom land had been allocated, who did the due diligence to know their worth? It is a shame to the Prime Minister and the ministers seated in front there, but actually what you are doing is unacceptable. Right Honorable Speaker, I don't object to giving land to anybody who has potential to develop. Actually, my view is different. My view, Honorable Speaker, is that let government act transparently. Advertise any public land which is available for development. That's how serious government do. And as a result of that, people would express interest. And when they express interest, you choose those who have capacity. Honorable Speaker, there are leases which are issued in respect of these alleged developers. Suffice to mention, Honorable Speaker, that there are always developmental leases. They give the first 5 years. I have ministers from the Ministry of Lands here. Even before the expiry of the 5 years, nothing has been done. These so-called investors are extending their leases to 49 to 99 years. I dare challenge any of you to stand up and say that's not the case. That's what they are doing. Right Honorable Speaker, some have even converted leases to freehold. In other words, they are even denying government revenue. Because if an alleged investor is having a freehold, he's holding in perpetuity. He has no business coming back to you. Finally, Right Honorable Speaker, when you look at these awards which have been done, if the ministry, you are controlling authority, when you are working together with Kampala Capital City Authority, why should you land allocated for another purpose? Why should they put another development which is not the one which had been intended? The question would be, Minister in charge of planning, when this place was allocated for that purpose, did you gazette it as such? These people are putting up houses who are claiming to be owners. Did they go and do change of land use? Then the other issue is, when the lease is given out as a developmental lease, it's not transferable, Honorable Speaker. This foolery, that is, the lease was given to Topec, and he started subleasing to other people without reverting to the one who's giving the lease. It's unacceptable, it's illegal. So I challenge the ministers here, dearly, you can do better. And Honorable Speaker, I want to end by saying that we can stick to the original offers. Issue directive, those who had been given those leases, to develop within a particular period of time within the developmental lease. And if it is not done, let us cancel all of them. Re-advertise, get actual investors in the real sense.
Thank you.
Short of that, Honorable Speaker, we are going to be having schemers. You have heard that the Minister of Lands is fighting with the chairman of the Uganda Land Commission. The squabble is about land. It has nothing to do with land management in this country.
Okay.
Because you cannot tell me that Uganda Land Commission, which is under the ministry, cannot be supervised by the Minister of Lands. It can't. The political head of that ministry is the Minister of Lands. Whereas Uganda Land Commission, when they are executing their mandate, they act within the law. So that's why, Honorable Speaker, I want to end by saying that the ministers, you can do better. I see my friend here, Honorable Musumba. She's on the lawyer and a very senior person. Honorable Chris Bariomuns. You can do better. I thank you.
Honorable Mbwa, then Macho, Kibalia, Achia, Amede.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, I wish to thank the chairperson of the committee for the report about scramble and partition of Naguru. Right Honorable Speaker, if I had powers, I would have sacked Honorable Kafero, because Honorable Kafero has been mean with facts. He has not pointed out that ministers are thieves, and basically, not all ministers, but this time, the land in question, the Naguru land, Honorable Betty Amongi, Honorable Betty Kamya, Honorable Betty Namugwanya, it's as if the name Betty is so sarcastic in this matter. Right Honorable Speaker, I wish to inform Honorable Kafero, if you're not informed, that all this fracas we are seeing is only brought by the three ministers who have tried to allocate themselves land, and they are sitting on interministerial committee, confusing our Mzee here, because he sits on the committee, but they are confusing him and they are passing papers here and there. But me, I have the facts. They've allocated themselves land. And they are trying to take away the mandate of ULC. And honorable members, it is the mandate of ULC, Article 238. So, I'm even wondering, I did not study law. An Attorney General coming out to say ULC should not proceed and give out land because if they did not get any authorization from the cabinet. Who is that attorney? Are these new attorneys from the field or the old ones? Is he the old one that we should trust? If we can misinterpret the law like that, then how about the people who are not land like the Mbwas here? So, right Honorable Speaker and honorable members, even Rocco, the one they are trying to give even some acres, it should not even get anything. Right Honorable Speaker,
Half minute close.
so, right Honorable Speaker, I don't think even Rocco should even get even 0.02 decimals, because it has only a shrub and it has failed takeoff. Who doesn't know that Rocco has been liquidated? And by terminating OPEC, it means Rocco has no grounds to claim. So, right Honorable Speaker, as I conclude, according to the information, these ministers of our government are trying to create slums instead of satellite cities. You cannot create a satellite city by giving 0.22 decimals. They've distributed all small lands and they don't even have powers, right Honorable Speaker. Shame! You people, shame ministers of this country. A total shame. They are doing us a disservice to this country. Honorable members, I pray, let ULC, Uganda Land Commission, stay with its constitutional mandate. I thank you, Right Honorable Speaker.
Macho, Kibalia Achia Mede.
Thank you.